Well, first of all, happy 79th Independence Day. And before we start today's important webinar, just wanted to give a brief introduction about our firm. We are Ashwa Legal Advisors LLP. Was founded in 2017 by our founder partner, Advocate CA Dr. Avinash Poddar and Advocate CA Achal Poddarji, and other partners in the firm being Shailin Doshi, CA Ashu Dalmia, CA Shefali Girdarwal, CA Vishal Poddar, myself, Advocate IP Pramod Dokania, Advocate Amish Desai, and Advocate Avdesh Sharma. We are a national level boutique law firm specializing in providing comprehensive legal assistance and litigation support across a broad spectrum of services. Our expertise encompasses both taxation in terms of direct and indirect, Prevention of Money Laundering Act, PMLA, Benami Transactions, Corporate Laws, including Companies Act, Insolvency Bankruptcy Code, SARFAESI Act, and other statutory act and legal services. Our firm is headquartered in Surat with branch offices strategically located in various locations, including Mumbai, Delhi, Pune, Ahmedabad, Nasik, Vadodara, Faridabad, and Gurgaon. In addition, we maintain a robust network associates offices across India, enabling us to provide seamless legal services and comprehensive support to our clients spread nationwide. With that, I think today's webinar is basically focusing on uh, an important topic, which is which Vishal Bhai will take us through. And as you said, the adjudication mistakes that kill litigation and principle of waiver that we are going to speak about today. So with that, I think over to you, Vishal Bhai.
Thank you, Pramodji. And yes, wishing you all a very happy 79th Independence Day. And I welcome all of you all once again to our platform. And many times when within we partners, we discuss about litigation, and when we are handling the litigation that is forwarded to us by all our associate partners, all the other professionals. So at that time, many times when I, Shefali ji, Pramod ji, Avinash bhaiya, we are discussing between us, we find that many times it happens that since we are handling at the higher forums from tribunal onwards, whatever has been done at the adjudication level, which may be either the pre-adjudication level, audit level, DRC 1A level, or at the adjudication level, show cause notice reply, we have found that many times, one, there is a lot of confusion as to how my reply should be, whether it should be detailed, whether it should be crisp. And two, many times we find that some very important critical grounds which should have been agitated, which should have been alleged, taken, have not been taken. And when we try to take up that at a higher forum or in a writ court, many times, despite of we having a very strong case, it may end up that the results may not be that favorable as what could have been had that particular point been agitated. So that is why, firstly, we are in a process of designing a very special 4-day per day 3-hour webinar series on this specialization of handling litigation. We have a very specific flood of requests from so many of the members with whom we are connected across India and whom we all keep on meeting in different forums, that what are the key insights as to firstly approach of handling litigation, and then once you enter into litigation, relating to drafting, relating to presenting yourselves at all the lower forums before the matter reaches to the higher forum. So we all partners are in the process of curating, and let me take this opportunity to inform you all that very soon we will be announcing this special webinar series for all those people who are deeply, keenly interested in taking up the litigation, be it of direct tax like income tax, or be it of indirect tax, which may be GST, which may be customs, etc. So let me and Shefali ji kickstart our today's deliberation, and then we will involve all the other panel experts to come up with the views. So Shefali ji, as we were discussing last day, that many times at the ground level, when the adjudication starts and when a professional is replying to any show cause, there are at times certain deficiencies in our replies which kills the possibility of having a very strong defense at the higher forum. So, Shefali ji, before I start with the presentation, I'll request your insights on this.
So the purpose for the today's seminar is to understand what should exactly be incorporated into our notice. And while we are replying a notice, while we are getting an assignment to reply a particular notice, whatever case we are getting. So किसी भी तरह का notice हो, छोटा हो बड़ा किसी का भी हो. So first question we should be asking to the taxpayer whether you want to pay this tax. The issue is we already assume that he is not going to pay the tax, and we already take up that whole responsibility on our head that somehow, anyhow, we will have to give that person the rescue from the entire tax burden. And that is the reason we generally feel shy in asking the fees, because we think it's our responsibility. तो उसने कुछ भी किया है, सही किया, गलत किया है. We think नहीं, our responsibility is that कि उसको एक पैसा भी कहीं देना ना पड़े. So if he has to pay anything, it's our failure. First thing. Second thing is, अब क्योंकि मैंने पहले ही सारी रिस्पॉन्सिबिलिटी अपने सर पे ले ली है, तो मुझे लगता है कि मैं फीस चार्ज करूँ तो इसका मतलब तो कोई श्योरिटी दो. So we need to understand what we are exactly doing, what any advocate is doing, or what any person who is representing someone at any stage of litigation. So up to tribunal as a CA we represent, or after that maybe as an advocate, up to tribunal advocate can also represent. So what is our role? What is our responsibility? So the first question we should be asking whether you want to pay the tax. भाई इतना लाइबिलिटी आपकी खड़ी है, आपको पे करना है कि नहीं करना है. एंड मैंने आज तक अपनी लाइफ में एक भी केस ऐसा नहीं देखा जहाँ पे टैक्स पेयर ने बोला हो कि हाँ मैं पे करना चाहता हूँ, नो मैटर हाउ बैड दैट लिटिगेशन इज. चाहे उसने खुद अपनी स्टेटमेंट में लिख रखा हो कि भाई मैं तो चोरी करता था, फेक बिल लेता था, मेरे यहाँ पे सिर्फ बिल आते थे, कोई माल नहीं. अपनी पर्सनल स्टेटमेंट में मे बी डायरेक्टर हैज रिटन इट हिमसेल्फ to the DGGI or to any investigating authority, but they will never choose from litigation and tax payment the tax payment option. क्योंकि 1 करोड़ रुपए मुझे अभी पे करना पड़ रहा है, ठीक है, कंसल्टेंट का फीस कितना होगा, लिटिगेटर का 50,000 होगा, 25,000, डिपेंडिंग जितना भी वो नेगोशिएट कर पाए. So who in this whole world will choose from 1 crore, 2 crore or say 50 lakh or 70 lakh and from 50,000 में से वो कौन होगा जो बड़े वाली अमाउंट पे करना चूज करेगा? वेरी रेयर ऑफ द रेयरस्ट केस दैट विल बी. Right. So we need to understand, first of all, ask that question to that particular person. Why, what is your take? You don't want to pay? Then always say that, yes, we can litigate it. So I am not giving you any surety of anything, but I am just telling you the possibility of litigation. So कोई केस ऐसा है जो बहुत ही मुश्किल है, ठीक है, कोई केस ऐसा है कि जिसमें possibility है. So what the duty is to give a fair idea to the assessee कि भी आपके केस में क्या हो सकता है, कि strong grounds हैं आपके, ठीक है, या फिर किसी में बिल्कुल भी नहीं है, कि आपके में काफी स्ट्रॉन्ग ग्राउंड्स नहीं है, बट इट कैन स्टिल बी लिटिगेटेड. लिटिगेट तो हर केस हो ही सकता है. आज तक मैंने ऐसा तो कोई केस नहीं देखा जो लिटिगेट नहीं हो सकता है. राइट. नाउ द सेकंड थिंग, सो वी ऑल हैव वॉच्ड अ लॉट ऑफ लॉ सीरीज. जो लॉ में इंटरेस्टेड होते हैं, लॉ सीरीज देखते हैं, हम लोग मूवीज देखते हैं. सो इट्स नॉट लाइक ए जॉली लिटिल बी मूवी कि एंड टाइम पे एक मरे हुए आदमी को मैं कोर्ट में लेके जाऊं, और जो इन्वेस्टिगेटिंग अथॉरिटी नहीं कर पाई, जो टैक्स पेयर भी नहीं कर पाया, उसके पास भी जो डेटा नहीं है, जो एविडेंस नहीं है, मैं एक दिन अचानक से जाकर उसको प्रोड्यूस करूं. दैट्स नॉट अ ड्यूटी. Our only duty is whatever material is put on the record from the both side, from the SSC side and from the authorities side, we should be thorough with that whole data, and we should always try to build our case based on this. So ऐसा नहीं है कि आप कई बार, I have seen that like people like हम दिन रात सोचते रहते हैं क्या हो सकता है. नहीं, जो भी आपके पास डेटा है, the important thing is we start from the judgment. लास्ट ही सेमिनार जो मैंने विशाल जी ने हमारी अश्वा टीम ने की थी, दैट वाज ऑन द सिक्पा जजमेंट, जहाँ पे मैंने यही बताया था कि आपको जो व्हाट्सएप पे जजमेंट का समरी आता है, यू कैन नॉट बिल्ड योर रिप्लाई, यू कैन नॉट बिल्ड योर केस बेस्ड ऑन दोज जजमेंट्स, बिकॉज दोज जजमेंट्स आर ऑल्सो हैविंग ए बैकग्राउंड. So unless and until you know the whole background, so सिक्पा में the court said कि आपको refund मिल जाएगा, but if you will know the background, you will understand that it's not a strong precedent. So while drafting the reply to a notice, what I feel the most important thing is the facts. आप फैक्ट्स को ही 2 बार 3 बार 4 बार 5 बार पढ़ोगे, आपको केस बिल्ड करने का जो पावर है वो वहीं से मिलेगा. आपको वहीं से सबसे ज्यादा आई विल से जो ग्राउंड है अपने मिलेंगे, फैक्ट्स को ही बार बार पढ़ के. what generally happens, जब हम फैक्ट्स लिखते भी हैं ड्राफ्टिंग में, बिकॉज एट अश्वा वी generally enter at a stage where the notice is already replied, or in some cases maybe appeal is already filed. So either we are taking care of the court or maybe appeal, दो ही जगह पे हमारा होता है. नोटिस के रिप्लाई के चांसेस होते हैं बट कम होते हैं. एंड एट अश्वा वी हैव filed like thousands of appeal and thousands of writs, so we understand. We have read the notice reply of like the different consultants from all over the India. नहीं विशाल, भारत के हर कोने में ही क्या नोटिस के रिप्लाई आते हैं, उनमें क्या लिखा जाता है. वी हैव अ फेयर आइडिया ऑफ दिस एंड ऑन द बेस ऑफ दैट आई एम सेइंग दैट कि हम लोग स्टार्ट करते हैं कि कोई भी जजमेंट मिल जाए जो डायरेक्टली इनडायरेक्टली बस किसी तरीके से उस इशू को कवर करता हो, मे बी इवन रिमोटली, एंड देन वी बिल्ड द होल केस बेस्ड ऑन दैट जजमेंट. दैट इज द बिगेस्ट प्रॉब्लम. वी शुड ऑलवेज स्टार्ट
Exactly.
फ्रॉम द फैक्ट. और
Exactly.
facts को मैंने देखा है कि जो हम लिखते भी हैं अपील में, तो फैक्ट ऐसे मतलब दो चार बातें जो ऑलरेडी है नोटिस में से चार पांच बातें बस निकाल के लिख दिया तो वो फैक्ट्स हो गया. इट्स डेफिनेटली नॉट लाइक दैट. आई थिंक जो अविनाश जी का हम लोग जो एक कोर्स अभी स्टार्ट करने वाले हैं ऑन जीएसटी 80, दैट विल बी ग्रेट हेल्प फॉर ऑल ऑफ दोज लिटिगेंट्स जो आगे जाके लिटिगेशन में अच्छा काम करना चाहते हैं, जो चाहते हैं कि वी डोंट इवन अंडरस्टैंड द इम्पोर्टेंस ऑफ फैक्ट्स. जब फैक्ट्स लिखने रिप्लाई में उसका क्या इंपॉर्टेंस है, ग्राउंड्स तो चलो ठीक है वी अंडरस्टैंड उसका तो कुछ इंपॉर्टेंस है, प्रेयर जो हम लिख रहे हैं उसका क्या इंपॉर्टेंस है, वी डोंट इवन नो दैट. इन वन ऑफ द केस, मतलब नॉट द जजमेंट बट केस की प्रोसीडिंग्स में सुन रही थी अभी एक हाई कोर्ट की, तो वहां पे प्रेयर पे भी कोर्ट को प्रॉब्लम था कि प्रेयर के अंदर आपने मेरिट वाला इशू पे लिखा और प्रेयर के अंदर आपने टेक्निकल इशू
Grounds.
लिखा है. तो कोर्ट सेड यू विल हैव टू डिसाइड वेदर यू वांट टू प्ले ऑन द मेरिट्स और यू वांट टू प्ले ऑन द ग्राउंड्स. आप ऐसा नहीं कर सकते. आप मेरिट पे भी यहाँ पे आके आप मेरिट वाला भी रिलीफ मांग रहे हो और आप आके टेक्निकल पे भी रिलीफ मांग रहे हो, सो यू विल हैव टू डिसाइड. और एट सम प्लेसेस दे विल से कि यू मे हैव टू डिसाइड एंड सम प्लेसेस दे विल अज्यूम. आपको डिसाइड करने का भी राइट नहीं, जस्ट बिकॉज प्रेयर में आपने मेरिट पे भी रिप्लाई दे रखा है, मेरिट पे भी आपको रिलीफ सीख कर रहे हो, आपने ऑलरेडी मेरिट्स भी कवर कर रखे हैं, तो कोर्ट में से दैट व्हेन यू आर रिप्लाइंग ऑन द मेरिट्स towards the point of fighting on technical grounds. So that's very important and I will say it's very complicated. And आज का जो सेमिनार है उसका गोल यही है कि at the time of drafting of notice, क्योंकि later ground पे हो सकता है आपका केस उसी वजह से रिजेक्ट हो जाए. कुछ जजमेंट्स हम लोग डिस्कस भी करेंगे जो हाई कोर्ट लेवल पे सिर्फ इसलिए रिजेक्ट हो गया. कोर्ट ने क्लियरली ये चीज बोली है कि आपका ग्राउंड अच्छा था बट आपने इनिशियल लेवल पे यू डिडंट कवर इट, सो दैट्स व्हाई वी कैन नॉट हेल्प नाउ. राइट.
And that is what is the principle of waiver.
राइट.
So today we are selecting you will this is, you can say, a glimpse of the upcoming 4-day course. So we are selecting this one very important doctrine, which is the principle of waiver. And as Shefali ji just explained, the importance of how to present your case. And in that, this point, what is the heading of our today's webinar? Adjudication mistake, which may kill litigation at the higher forums. In that, what is the relevance of contesting or taking your technical grounds at the very first stage of adjudication? This is what is relevant. So for this, we have selected a very recent judgment of Regent Corporation versus Union of India, pronounced very recently. I'll just give you a brief overview of this judgment so that it will set a tone for deliberation further. You will realize the magnanimity of today's topic as to how not raising a ground at the first best possible stage, that is show cause reply, how it has adversely impacted this particular judgment, though the honorable court had even appreciated that yes, this ground is maintainable, but you were supposed to take it at the lower forum. So now the question that we are going to start with is, what if a substantive ground you missed to raise at the adjudication stage? What could be the impact? So the basis of this is the present judgment. So in this judgment, we are not going into the facts of that because our focus discussion is today on one of the principles, that is principle of waiver. So this particular judgment, obviously, since it is a writ order, so basically, as you all know, in writ, always the first thing that is contested by the counsel from the department is that you cannot entertain this writ only because a major reason is that there is an alternate remedy available. So when this writ started with this whole argument, the learned counsel, that is Avinash Podarbia, who was contesting from the petitioner side, had posted some very strong grounds. One of which, as you can see in para 5, is that the officer who conducted the audit has also conducted the adjudication proceedings. So, dear participants, this is again a very important doctrine, a legal maxim, which is nemo judex in causa in sua, which means the person who is investigating, the person who has done the preliminary work, cannot be the judge of his own work. So an investigating officer cannot be a judge. This is, in simple words, the meaning of this Latin maxim. And let me inform you, this is one of the major grounds which I believe you all should take whenever you find that the investigating authority is also your adjudicating authority, as in this case, the person who has conducted the audit was also handling the adjudication. So this particular pertinent ground was raised. And secondly, it was further that the principles of natural justice have not been complied with, fair opportunity of replying and fair opportunity of submitting the counterclaims have not been provided. Now, as against this, the learned department leader had pointed out, now this is the most important part, she pointed out that none of these cases, the objection which is based on the allegation of bias. Why bias? Because the same authority is also your adjudicating authority, was ever raised before the adjudicating authority, and the petitioner took their chances. That is, so what she pointed out to the honorable court is that this particular ground, which now you are taking here to get your writ admitted and get a relief, should have been taken at the lower forum, which you did not take. Rather, you took your chances on merits. And then, since you could not maintain your case on merits, hence you are coming here and taking this ground in the writ forum. And then she also highlighted that only adjournments were being applied for, and considering the fact that the adjudication proceedings have to be disposed of expeditiously, maybe the department may not have provided the adjournment. So she accepted that maybe certain adjustments requested were not provided. That may be because of the reason that it was necessary because of the paucity of time to complete. Now, against these submissions, the Honorable Court made some very important observations. I am putting out the important ones. So, Honorable Court pointed out that any patent breach of natural justice is a sufficient ground to invoke the writ proceedings. So, she accepted that, Honorable Judge accepted that. However, it was pointed out that for reasons briefly discussed below, we do not believe that the practice of exhausting alternative remedies should be departed from. So despite of accepting that a breach of natural justice is a sufficient ground for writ, however, based on certain facts of this particular case, she said that writ is not maintainable. What are these grounds? This is the main point in the order. Regarding the arguments which is based on the bias aspect, that is the nemo judex causa insua principle, that is the audit officer cannot be the adjudicating authority. It She also accepted, in fact, in the observation, it was pointed out that this issue was never raised during the adjudication process or even in response to the reply to the show cause. And the petitioner took the chances, participated in the proceedings, and only after adverse order was made against them, they now are raising this issue at the higher forum, that is in the writ forum. Further, what is highlighted? Assuming that such circumstances suggest bias, that is the same authority is doing your adjudication, there is equally another principle about waiver, particularly in context of allegations of personal bias. So where on one side you are contesting this personal bias, there is another equally applicable principle in judicial forum, that is of waiver. And what is this waiver principle? You participated in the proceedings and you did not agitate this matter at the first instance. It means by doing this act of participation and not agitating this particular ground, you have accepted the defect, and this is the principle of waiver. This is our key point of discussion. See, these are some very important doctrines that we are going to discuss in detail in the 4-day course. But what is very important to be highlighted over here is that though this could have been a very strong ground to drop the proceedings to get a favorable order, however, because of the countering principle, that is the principle of waiver, that you did not raise this particular ground, hence since the petitioners participated in the proceedings without any demur, it is arguable, as argued by the learned department counsel, that there is no serious violation of principle of natural justice. So we do not wish to dismiss the petitioner. Now this is interesting. They accepted that they do not diminish the petitioner's argument about bias. So they are accepting that maybe there could be the possibility of bias, but since you did not allegate this earlier, hence they are remanding this matter back, and they are allowing you, remanding means they are now allowing you to file the appeal with the appellate authority and take up this particular issue at the appellate authority forum. So what is clarified in the order? Further, that all contentions of the parties on merit, which will also include the challenges based on bias and also the challenge of not providing reasonable opportunity, are kept explicitly open. So in the remarks, this particular ground has been kept open and the parties are ordered to allegate this at the appellate forum. So this is one of the relief. I'll say it is not completely an adverse order for the petitioner. So they have got a relief that at least they are allowed to now recontest this issue. But an important point that we get to learn from this particular judgment is that had this point been alleged earlier, maybe today this writ order would have had a different scenario. Now, before we start discussing on this principle of waiver, because see, this is equally applicable to direct tax litigation plus indirect tax litigation. But in case of GST law, there is this one very important section 160, which I believe we should all revisit, and then we open the forum for a discussion. So what does 160 deals with? It deals with assessment proceedings when not to be considered as invalid, that is when to be considered as acceptable. So the subsection of section 160 firstly says that any assessment proceedings or reassessment, adjudication, summons, etc. will not be considered as invalid merely because of reason of any mistake, defect, omission. So like many times we find that some basic thing is missing, some wrong section number is quoted, or any such minor clerical defect is there, that will not entirely make the proceedings or make the action by the department invalid. But what is of more important for today's discussion is the subsection 2. What it says: the service of any notice, order, or communication shall not be called in question if the notice, order, communication, as the case may be, has already been acted upon by the person to whom it is issued, or where service has not been called in question at or in the earlier proceedings. Most important principle of waiver is also highlighted in section 160 bracket 2. So with this backdrop, I would like to invite CA Dr. Avinash Podar Bhaiya on the forum to share his insights on both these aspects. One, the doctrine of principle of waiver, and two, this aspect which is covered in section 160 bracket 2, and what are the precautions, way forwards that we all present over here can take away in our future assessment proceedings.
Vishal, first I would suggest that you proceed. You have a discussion. You discuss this 160 clause 2. As per your views, Shefali ma'am should also share, Pramod ji should also share. Then if any queries will be there, I'll take up those queries. And so far as the principle of waiver is concerned, I'll share my experience.
Okay.
And some of the other judgments are also there, which I want to highlight.
Okay.
Wherein the Supreme Court has clearly said that if we are not responding to the show cause notice, it is indirectly, it will be treated as admission that you have agreed to it.
Okay.
So we'll go with that.
Okay. So Shefali ji, your views on principle of waiver and read with section 160 bracket 2.
So, under section 160, there is a specific requirement of questioning the questionable proceedings. So, in case there is any technical issue, so what can be the possible technical issue? So, there can be two different sources for the technical issues in any proceedings, any notice or even order. The first is the principle of natural justice, the principles which are not written anywhere, but through the jurisprudence of the different judgments of the European Union, which are adopted by India, and through the different judgments of India, now it is even, I will say, more sound than what is written in the law. So they are not directly written into the law, but still they hold a very strong ground in Indian litigation specifically. So there are different principles of natural justice. One which is very famous is that a person should be given an opportunity of being heard, and that is a source from where the birth of SCN, that is show cause notice itself, has taken place. So we are sent a show cause notice because we should be given an opportunity of being heard, and this is one of the principles. Other principles are not that important and are actually not used on the daily basis, but there are some other principles also, and one of those principles is that no person should be a judge in their own case. So a person should not be on a deciding position where something already decided by them or something against them or something which was already even investigated by them is under the question. So in this particular case, the question was that no person should be a judge for their own case. So in this case, what happened? The person who audited, who set the ground for it, the same person was there for the adjudication. So someone who is auditing a case, and if the same person is adjudicating, there is a possibility of bias. It's very natural. So this was one of the, I will say, permutation combination. There can be multiple combinations for the same thing. So if the same person who is at one stage taking care of something and at the other stage also the same person is taking care of it, so there are chances of bias. So this was one of those sources. It was coming from the principle of natural justice, PNJs only, right? Then there is the another set of sources. The another set of technical grounds can be the procedure which is already being laid down under the law. So in the law, there is already a procedure like how a notice will be sent, like what kind of authority can send what kind of what kind of notice. Then if it is ultra jurisdiction or an authority which was not having jurisdiction on you, if a particular notice is sent by that kind of authority. So first of all, we should be having a detailed knowledge of all of those grounds. So let's suppose law is saying that you will have to issue a DRC 01A, but that's not being issued. The other example can be, let us say, there is a circular of CBIC wherein they have said.
Sorry to interrupt, ma'am. There is a request that you speak slow. Your speed is a bit fast.
Okay. So yeah, so I was telling the different sources for it. So another instance can be like in a particular circular, the CBIC has set a limit for different authorities to issue the notices. So if a notice of higher amount is being issued by a lower authority, so that can be one of the technical grounds. I'm just giving the example of some of the technical grounds. There can be many. So if somehow the principle of natural justice are not being followed at the time of notice, so proper opportunity is not being given, and I will say it's not something fixed. It will be depending on the circumstances of each and every case. So, in many cases, the court will support the principle of natural justice, the principle that opportunity of being heard may be given or not given. But in some case, if somehow you are already aware of the grounds in notice, then court will say that no, you already had the enough opportunity to answer those questions. So why it is important? It is important because unless and until I will know the exact grounds, how I will be going to reply for those grounds. That is something which happens in PMLA. Because in PMLA, when you are going at the first hearing, you don't even know the proper grounds. At many instances, the courts have opposed it, but this is how that law is made. So, principle of natural justice, first thing. Second thing is the procedure which is already laid down in the law itself. So, section 160 says that if there is any of such ground, any of such defect is existing at the time of notice, we are supposed to question the questionable proceeding. So if it's questionable, we are supposed to question it. If we don't question it and we make a reply on the basis of merits, we make a reply, we are going for the hearings, then we will lose our right to question and we will not be able to get any relief at a later stage because it will be assumed that we have accepted and it will make good for that particular defect. So this is the provision section 160. If you are not questioning the defect at the initial level, you are replying the notice, you are taking part in the adjudication or whatever kind of proceedings. So later on, once you get the adverse order or at any stage later on, you cannot raise that particular point that there was any kind of procedural defect into that. So this itself is incorporated into the law. So while you are making a reply of a notice, I think what we should do, we should divide it into two parts. So first part is we should check whether there is any, I will say any breach of PNJs or if there is any breach of any of the procedural law. That is the first part. Second part will be we should go through the merits of the particular case. And I will say that see, replying a notice is not like a 2020. It's like a test match. So you want to choose the batting or the bowling, you will have to decide on day one, taking care of the weather conditions of even day 5. I mean, you will have to decide it in long-term view. So whether you want to raise a technical ground, you can directly file a writ to the court and say, technically this notice is not good, right? Or you want to go with the merits. If the case is on the basis of merit is actually very weak, you can also choose to go with the merit. But it will be, I think this is the decision making we should be having at the time of replying a particular notice. And any mistake at that level may actually make your case miserable at the later stage. And there may be some irreparable losses at the later stage, which you will not be able to repair. So I will say that is the day one when you should be deciding whether you want to go with the technical or you want to go with the merits, or you want to somehow incorporate both of them into your reply. That is from my side.
Great. So basically, the issue under discussion is that what is this principle of waiver and what is the gravity of this principle of waiver, specifically after considering this section 160 bracket 2. So I'll share my understanding. So basically section 160, if you read both subsection 1 and subsection 2, are, I believe, in a sense, a way of defending or giving a protection to the department for whatever clerical mistakes they have done, or let us say if there is any technical defect, if there is any technical mistake at their end. So even subsection 2 takes care of that. But there is a difference in subsection 1 and subsection 2. Subsection 1 upfront says that if there is any clerical mistake, that would automatically be considered as ratified. But subsection 2 makes a specific exception, or I'll say make a specific condition, that in case the petitioner, the noticee, has acted upon the same, a defective notice, a defective communication, or something which is outside jurisdiction or which is technically not correct in law, and this particular point has not been alleged, has not been agitated by the petitioner, by the noticee, then section 160 bracket 2, as per my understanding, provides a shield to the departmental actions, whereby the defects in the service of the notice, order, or communication will get ratified by this principle of waiver. So in short, as a noticee, as a taxpayer, you have certain rights. These rights are inbuilt by the past jurisprudence, and maybe keeping that in mind, I believe section 160 bracket 2 has been incorporated into the GST law, so that if a similar thing happens again in the GST law, where we have the past settled jurisprudence, that if something is defective and if something is not as per the law, then the entire proceedings can be quashed. I think this point will get a type of a toss because of section 160 bracket 2, in case we do not argue, that we do not raise this particular ground at the very first opportunity. This is my understanding. If anybody else would like to share, or then we can go to Avinash Bhaiya. Yes, Pramod ji.
I think just to add, I mean, as you said, doctrine of waiver is a legal principle where the party either voluntarily or knowingly relinquishes its known legal right, and it can be either express or it implied also. So if from the conduct of the party during the adjudication process and by not protesting the known issue in terms of jurisdiction or any procedural lapses on behalf of the department, if that has not been challenged, then those would be considered as waiving their rights, and later on the same party cannot raise the same issue in a higher authorities in terms of writ or anything. So I just wanted to add that.
Great. So over to you, Avinash Bhaiya.
Yeah, thanks. See, let me start with saying this. There is a purpose with which a show cause notice is being issued. The purpose is to provide an opportunity to explain or to defend the allegations which are made. Explain because the officer has to explain why those allegations, and defend because the respondents or the noticee has to respond back that why those allegations are incorrect. Now, supposingly there are 5 allegations in a show cause notice. We are focusing on one allegation and we are replying back on that one allegation, and rest of the 4 allegations are not replied back. That is one probability. The another probability is what is being discussed up till now, that is waiver. When there is a technical flaw, maybe the limitation flaw, maybe the jurisdiction, maybe the authority, there can be a number of situations which may arise which uh, uh, is not in accordance with law, and therefore it may not be validated or having a credential on merits, but certainly when it comes to technicalities or technical flaws or the jurisdictional aspects, then that can be a very, very valid ground to be raised. For example, nemo judex in causa sua. We were discussing that the person who is investigating, if he has been given the chance of adjudication of the same, obviously he is not going to turn around his own show cause notice. But we cannot say that he will never turn around, because there may arise a situation that while doing investigations, he was taking a particular view and therefore issued a show cause notice. And then thereafter, when you are defending and submitting all the documents, he is taking or turning his view and passing an order in your favor, but that the probability is very less. So the point which I'm trying to raise is that obviously, when, as already indicated by Shefali ji, that the response to any show cause notice has to be on two counts: one, the technical flaws, and two, the merits. So first and foremost is the technicalities, and then comes the merits, I would say, or rather I would put it in this way, when we are going for a writ petition. Because writ petition, as we all know, and Vishal bhai has already said that, there is a very important aspect which is with respect to maintainability. Remedy is available with the taxpayer. There are exceptions, but exceptions cannot be read as a law. Law has to be read in totality, and the exceptions has to be understood why those exceptions are. So for maintainability of a writ, availability of an alternate remedy available, writ is not maintainable. But at the same time, the most important aspect which I would like to point out is that although there are exceptions, but the general grounds that we take before the writ court is principles of natural justice, or the jurisdiction, or the authority of law, or the challenge to the virus. These are some of the grounds on which we can go for the alternate, or we can choose not to go for the alternate remedy exhaustion, and we can file a writ petition. Now, what happens is, generally I've seen that while filing a reply to the show cause notice, we are very considerate. We consider the relationship with the officers, that the officer will feel bad if I am pointing out that you do not have jurisdiction of issuing a show cause notice or adjudicating this, then he will feel offended, and therefore we do not write it. If the officer has issued a show cause notice and he is the same authority who has conducted the audit or investigation, we participate without raising this technical objection that a person cannot be judge of his own cause. Now, what happens is, as per the settled jurisprudence, the law of acquiescence comes into play. Law of acquiescence says that whether a person, or if a person gives a passive assent, because you have not assented it actively, you have given a passive assent by not raising that particular objection while replying to the show cause notice. So acquiescence gets hit, doctrine of acquiescence, or maybe the principle of acquiescence, and that is nothing but the doctrine of waiver. So waiver is what? Waiver is that when there was an illegality, there was something which you wanted to point out, or you ought to have been pointing out, but you choose not to do this. And you replied to the show cause notice on merits in spite of replying also on the technicalities. So therefore, considering the merits, the order may be passed. So when this comes into play, it becomes difficult for us to plead the same objection which was never objected at the inception, at the show cause stage, before the higher forums, as rightly said by Vishal bhai. But there is one very important aspect to it, which is doctrine of estoppel. That has to be appreciated by everyone and or who wants to or who is willing to go for litigation practice. Let me take 1 minute and diverge to an extent. See, nowadays everybody wants to be in litigation practice. And it's a very welcome thing because everybody wants to elevate and they have to and they should elevate. But at the same time, there is a huge mindset difference which is required to be there when we want to practice litigation. And at the same time, litigation practice requires, or rather litigation requires, that each and every aspect that has to be countered strongly must be countered strongly. If we are sitting tight on something or sitting silent on something, that may create a problem for us, which happened in this case. Because at the adjudication level, had it been a case that they would have pointed out that he cannot be the person who can adjudicate, so maybe the fate of that particular judgment would have been different. But since they have chosen not to do that, and they took their chance by participating in the proceedings, and when the negative order was there, they have now pleaded. So that has gone against them. So what I am pointing or I am trying to point out that estoppel means estoppel or doctrine of estoppel is very important, that we cannot be contrary to our own submissions. If we have not objected something at the show cause stage, now at a later stage we cannot object that. That will be contrary to our own submissions because the acquiescence or the waiver has already triggered. The moment you choose not to reply to a particular allegation, it means that you have indirectly admitted it. And there is a judgment, you can note down, there is a judgment of Brindavan Beverages. Brindavan Beverages is a judgment wherein the Honorable Supreme Court has said that allegations which are there in the show cause notice, it has to be specifically dealt with and rebutted. If you are not, or if you are choosing not to rebut a particular allegation, it means that it is accepted. So Honorable Supreme Court in 2007 in Brindavan Beverages has clearly held this principle, which was followed by multiple judgments, including the Hindustan Construction Company Limited, and recently Amit Kumar Jain in 2023, again Supreme Court. N number of other judgments are there, but these are a couple of the judgments wherein specifically the pleadings at the stage of show cause notice or at the inception stage is dealt with. And therefore, most important is show cause. I always say that the basis or the base is very important. Because if the base is created strongly, then you can have a 20, 40, 50 floor building. If the base is weak, then it may be difficult to create or to develop a 5-story building. So therefore, if you want to have a taller building or a taller litigation practice or maybe the submissions which are very correct, then you will have to build or you will have to have a very strong base, and the base is always built at the inception, which is the show cause stage. So these are a couple of judgments which is specifically dealing with the pleadings at the show cause stage. So if we do not plead at the show cause notice stage and the order is passed adversely, then at a later point in the stage or in the appellate forum or maybe before the writ forum, if you take that objection, then certainly it may come in your way that why you have not taken these objections at the earlier stage. This is what has happened in the in this particular situation. So therefore the question is how to rectify these mistakes. See, nobody is interested in listening to what has happened. Everybody is interested in listening how to resolve this particular issue. Whether we are in a position or whether can this issue be resolved at any point in time. The answer is yes. The answer is yes. But we are at the mercy of the appellate authority. He may not. He is not bound to permit you to make those additional objections at the appellate stage. And also please appreciate that these all depends on the facts of that particular case. It cannot be a straight jacket formula which can be applied in all these cases, all the cases. It is depending on the facts of each case. But important is, or rather the principle I would say is that we cannot go back and change the facts. Facts are that the show cause notice stage, the objection was not taken. And therefore the writ is disposed of, or I will not say dismissed, because though the court was, or the learned judges were kind enough not to dismiss the writ, they have disposed, appreciating the submissions. And while disposing, what they have said is that all the rights are kept open, meaning thereby you can go before the appellate forum and you can take all these objections that you are taking in the writ petition before the appellate forum, meaning thereby even this nemo judex in causa sua argument can be now taken in the appellate forum, although it was not there at the show cause notice stage. So if there is an alternate remedy, now let me take 1 minute to explain this also. There is a huge difference between the writ remedy and an appellate remedy, alternate remedy in the law statute. And settled jurisprudence or settled principle I have already explained. Since Whirlpool till today, commercial steel and a lot of judgments like Magad Sugar is there, which is the recent one. The Supreme Court has said that if there is an alternate remedy, we will not intervene. You go for the alternate remedy, writ is not maintainable. This is how the law is developed. But at the same time, they have given certain exceptions. If you are falling within those exceptions, you can certainly go to the writ court. All those exceptions are already there in Whirlpool and in commercial steel, in Magad Sugar, and everywhere it is there. Without jurisdiction, without authority of law, when you are challenging the particular virus of that particular provision, or maybe without jurisdiction, and violation of principles of natural justice. In these 4 situations, you can directly go to the writ court. But please appreciate, when you are going to the writ court without exhausting the alternate remedy, the writ court will look into these 5 parameters or 4 parameters which I have just stated, which is there in the Whirlpool Corporation, or which is there in the commercial steel, the 2021 judgment of Supreme Court, or Magad Sugar, which is of 2022. In all these judgments, the 4 exceptions are carved out, and therefore we need to make out our case with respect to maintainability of writ, provided we fall in any of these 4 situations. And even otherwise, even if we are falling into this, any of these 4 situations, the court has a discretion. I'm saying you cannot say that court will have to admit the writ. The court has a discretion and the court may relegate you to the alternate remedy. Now, in this case, the court has relegated us to the alternate remedy. Now, the question is how to rectify this particular error. And the answer is, while filing this writ, the first appeal or the second, at any stage, let it be, at that point in time, you can raise this objection. Now, as an additional ground, you can raise an additional ground of appeal, and you can raise this objection saying that this is an additional ground which I am now placing for the very first time before the learned appellate authority. And then it is at the discretion of that appellate authority to accept or not to accept. So if you are able to make out a case, then there may be a situation wherein the appellate authority may admit it. And if you are unable to make out your case, then these additional grounds will not be admitted. And therefore, there is always a risk. So the final suggestion would be, whatever you do, it has to be at the stage of the show cause notice. And in many of my sessions, what I regularly say is, you anticipate that this is going to be disputed by the department, and you will have to go to the appellate forum. Keeping that in mind, you draft your replies, so that whatever can happen, if there is any substantial question of law, raise that question of law also. If there is a question of fact, it is only to the question of fact. Please raise those question of facts at that reply stage itself, so that it can help at the appeals or at the writ stage. Otherwise, if we miss that, it will be difficult for us to regain that particular deficiency to be rectified. Now coming to section 160. I have a different way of reading section 160 subsection 2. See, subsection 2, as per me, as per my reading, is not related to any assessment proceedings. It is only and only related to service of the notice, or service of the order, or service of the communication. I'll read this in conjunction with each other. I'll not read it separately. It is service of any notice, comma, order, or communication. It has to be read with service. And therefore, if there is any question with regards to the service being bad in law, and you do not raise that objection, then in that case, it will be presumed that you have waived it. This is how I'll read it. So let me read it again. The service of any notice, it is there on the screen. The service of any notice, comma, order or communication shall not be called in question if the notice, order or communication, as the case may be, has already been acted upon by the person to whom it is issued. So meaning thereby, if there is a, let's say, error in notice, or the service is not proper, service is absolutely not proper, service has not been done, whereas I have already replied to that without raising the objection that the service is improper, then I am of the view, or where such service has not been called in question at or in earlier proceedings, commenced, continued, or finalized pursuant to such notice, order, or communication. So my say would be only restricted to this service component. I'll not go into the merits component. Merits component is there in subsection 1, which says if there is any assessment which is faulty, if there is any reassessment or adjudication review, if it is faulty. So that does not mean that the entire proceedings will be held to be invalid. If those errors are the apparent errors. So let us read that also. No assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or any other proceedings done, accepted, made, issued, initiated, or purported to have been done, accepted, made, issued, initiated in pursuance of any of the provisions of this act shall be invalid or deemed to be invalid merely by reason of any mistake, defect, or omission therein. So if there is some error which is there in the law, it will not invalidate the entire proceedings. Meaning thereby, if the search has been initiated and there is some error in the initiation or in the, let's say, the search warrant, then that doesn't mean that the entire proceeding will be invalidated. Important is we need to participate with those objections. So therefore, that defect can be removed, but it does not invalidate the entire proceedings. So let me read in totality. Shall be invalid or deemed to be invalid merely by reason of any mistake, defect, or omission therein, if such assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or any or other proceedings are in substance and effect in conformity with or according to the intent, purpose, and requirements of this act or any existing law. So this point is qua the technicalities. The technicalities does not come into the valid proceedings. The errors or the defects can be cured. It will not declare the entire proceedings invalid because of those technical mistakes. For example, DRC01A was not DRC01 was not uploaded electronically. It was served by post. Now, Rule 142 Subrule 1A says that it has to be uploaded electronically. But have we read anywhere in the law how to be uploaded electronically? Whether it is to be uploaded on common portal or whether sending on mail also is electronic service? There. I'm extremely sure it is not there. But it says electronically, so therefore we are presuming it means electronically means it will be uploaded. It has to be uploaded on the common portal. But law never says that expressly. So therefore, there can be an interpretational issue. There can be a dispute pertaining this. That department will say we have sent on mail. That means electronic service is being done. So those are the errors which we can raise after the conclusion of the proceedings. And if there is really a mistake, but the context of the entire proceedings is within the purview of the provisions of the law, then that will not invalidate the proceedings qua or per se. I hope I'm clear in saying this. So this is to an extent another issue, or rather, I would say this is giving a upper hand to the authorities. It is not in favor of the taxpayer. Even after doing a mistake, his proceedings will be upheld because of section 160 subsection 1. He has not followed the procedure because see, please refer Nazir Ahmed, please refer Swastik Polymers. There are those judgments which says that if a procedure is laid down in law and the procedure is not followed, the entire procedure will be said to be non-ist. It is invalid, illegal. Now, in light of section 160 subsection 1, can we say that if the procedure which is laid down in law is not followed correctly, it will be declaring the entire proceedings invalid? The answer is no. Because it clearly says, I'm reading it again, the last 2 lines. If such assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons, or other proceeding, it includes everything in the 4 corners of GST, are in substance and effect in conformity with or according to the intent, purpose, and requirement of this act. So if we are able to prove, if the officer is able to prove that, sir, my purpose was very clear to unearth the evaded tax, and therefore the show cause notice was issued in haste, and I could not upload the RC01 electronically. So that error can be repaired by virtue of 161. So I'd say, in spite of, or rather, we should avoid teaching this 160 to the officers. Let them read on their own. Why we are training them? We are not here to train the officers. We are here to train the fraternity, the professional brothers, that how to safeguard themselves from this. That is something which is very important. So this is what I will say, that 160 has to be read in different perspective. Even subsection 2, I'll read in that perspective only. Or if there is any confusion, we'll take up some questions and answers. So I'll conclude by saying this 2 things. 1, most important stage is the show cause stage, which is mostly taken care by a compliance person, a chartered accountant or an advocate or a tax consultant who is handling the compliances. Because whenever a notice will come, no, so the person who is filing the return, most of the times the client will go to him, the notice will go to him. Ki, sir, ye return bhara tha, there is some notice which I have received. Kindly comply with that. So first and foremost, a compliance mindset and a litigation mindset is totally different. The parameters of, I'll say, of a compliance professional within which he is working and the parameters of the litigation professionals is on a different compass altogether. I'll give an example. A compliance person will always focus on on the compliance of the notices that he has received. A litigator will always look into the infirmities or the irregularities or the illegalities in the notice that he has received, and then he will file a reply. So you can make out the point which I am trying to canvas. The moment you receive a notice, you go into the merits and reply to the notice. That is how a compliance person does. A litigator, the moment he will receive a notice, he will look into who has issued it, whether he was having the authority, what was the last date when it was supposed to be issued, whether the monetary jurisdiction is there or not, whether the territorial jurisdiction is there or not, whether the section within which it has been issued is correct or not. First, he will satisfy himself to those extents that first let us see the context and then go into the merits. So therefore, the reply to the show cause notice is extremely important. Whether you are a compliance person or you are a litigation person, that doesn't make any difference. To be very honest, it doesn't make any difference. I also practice as a chartered accountant for 17 years. So it doesn't make any difference. The important is you have to have that mindset of replying back very strongly to the show cause notice on each point which is alleged against you. Don't keep any stone unturned while replying to the show cause notice. Because please appreciate, you cannot blow hot and cold at the same point in time. Meaning thereby not replying at the show cause stage and taking that at the appellate stage. Not permissible, sir. Not permissible. You cannot be permitted for adopting the procedure of hot and cold at the same point in time. या तो आप गर्म पिएंगे या ठंडा पिएंगे, दोनों नहीं पी सकते. That will create a problem. So same is the doctrine of estoppel. So doctrine of waiver is important, but at the same time, doctrine of estoppel comes into play, wherein it says that if you waive something, if you do not reply to something, that means it is a contrary view that now that you are taking at the subsequent stage, which is impermissible in law. With this, I'll hand over to Vishal.
There is just one follow-up question, Bhaiya. Now in GST, we have this 1A stage. Many times, even nowadays, they send some letters intimating your liability or alleging some liability. The question is that whether the same stand should be there for at 1A stage also, because many times we say that since show cause is the starting point of the proceedings, and we want that if some mistake is there, some defect is there, we do not want to highlight it at the 1A stage, so that if by chance that comes to the show cause stage, then we will take that matter. So whether the answer will remain same for replies to 1A, that we have to allegate still and highlight all these defects.
First question is whether one is mandatory or not. The answer is yes. If it is adverse, then one is mandatory. Second question would be second answer would be yes. See, what is the purpose of pre-consultation show cause notice or intimation? The purpose is whatever you have to plead, you plead there in the 1A. Because the purpose is to reduce the litigation. ऐसा दिखाया जाता है. This is how we are taught. Illusion है. I would say it is an illusion by the department saying or by the government saying that हम pre-consultation show cause देंगे, and if you participate in pre-consultation and if the officer finds it correct, the show cause notice will be dropped. Generally, it doesn't happen. So therefore, I'm saying it is an illusion. But yes, the one-liner answer would be yes. You must reply in totality. See, if there are two kind of 1A. One 1A comes wherein only the amount is written. There is no description. Even to that, you need to make a reply saying that what allegation is there. Please kindly explain those allegations. Second one is that which is almost like a show cause notice wherein the allegations are there in detailed one. So you have to reply. And if he rejects all those submissions and issue a show cause notice, then it is a very good case for a writ petition. Because that becomes a premeditated show cause notice. It is a pre-adjudicated show cause notice wherein he has already taken a view. Now, what other view can be taken? Because 1MA, if you have submitted and all those submissions are either ignored or maybe rejected without giving any reasons why he is rejecting, and a DRC 01 or show cause notice is issued, that means it is a premeditated show cause notice. And therefore, Oryx will be applicable, that Siemens Limited will be applicable. Supreme Court has said that at the stage of show cause notice, you can go to a writ court for getting that show cause notice quashed.
Perfect.
Yeah.
Perfect. Now it is already 6:30 plus. So should we
Yeah.
take any questions or we can
One or
close?
two. How many questions are there? There are many questions.
There are few questions, but I think should I unmute Subramaniam ji? He has raised his hand for the second time.
You may.
Yeah, Subramaniam ji.
Sir, I have two questions. The first question is, can we raise a general ground saying that
There is no voice.
You're not audible.
so can we take a general ground saying that notice itself is invalid, whether in such a situations, whether this principle of waiver is applicable? Second is, show cause notice, I didn't raise certain legal issues. Can I raise the legal issues at the time of filing an appeal before the tribunal or writ before the High Court?
See, I think we have touched upon both. First, the general. I will not recommend any general replies. It has to be very specific. You need to be specific to the allegations. So in the show cause notice is invalid, cannot be a reply. Why it is invalid? And for what allegations you are saying, or on the basis of what allegations you are saying that it is invalid, must be pointed out. Number one. Number two, when it comes to the missing of the legal grounds at the inception and then going to the appeal or maybe the writ court, the answer would be yes, you can do that. but the discretion will be of the appellate authority or the tribunal to allow that additional ground or to dismiss your additional grounds. Because there is a procedure for tribunal, there is no procedure for first appellate authority. So if you miss in the first appellate authority and go in the second appellate authority, that is tribunal, and you raise an additional grounds, there is a procedure laid down in law in the rules, which says that you will have to fill a miscellaneous application saying that additional grounds you are filing, you will have to pay certain fees for that, and then there will be a separate hearing of acceptance or rejection of that particular additional grounds, and then it is at the discretion of the court or the bench whether to accept it or to reject it. So it may be a case once missed, always for it is missed forever. So don't take that chance.
Great. There's one interesting question that this principle of waiver, whether it is not waiver, nemo judex causa in sua, whether it is applies also when ASMT 10 is done by an officer and the same officer is taking up your show cause adjudication.
What's the question? I'm sorry, ma'am.
That the officer who has started the ASMT 10 proceedings, and after conclusion of that, if the same officer is raising a show cause, so whether this same nemo judex causa will apply. So can you take that allegation?
It will not apply.
Yeah, means it is allowed.
It will apply only when he is stepping into the shoes of an investigator or the audit function is being done. See, scrutiny is not an audit function. Read section 61 very cautiously. 61 only permits the scrutiny of returns. But if the question or the allegation is outside the returns, then it pertains to the investigation, which is not the scope in ASMT 10. So certainly the answer would be no. And please read the judgment which was pronounced yesterday by the Honorable Apex Court in Armor Securities. It's very clearly saying what about the proceedings and how those proceedings are to be dealt with. I think Vishal Bhai and Shefali ma'am, we need to take these two judgments as earliest as possible. Armor Security and the Kesri Nandan, which are recently pronounced by the Honorable Apex Court.
We can have a next webinar on this.
Both these judgments are very, very important because some very important principles are emerging out of it with respect to the proceedings and the summons and those initiation of those proceedings. Beautifully drafted and beautifully written, authored by Justice Pardiwala. It's a great judgment, I would say.
Great. So I think our next session topic is already finalized, armor security and Kesri Nandan. So I think majority of the main questions have been addressed. So I think it was a very well articulated discussion by Avinash Bhaiya on the critical aspects. So yes, Shefali.
Still there. If we have a couple of minutes, we can take some of the questions are also.
5 minutes we can have.
5 minutes. So one question is of Rahul Malhotra ji. Can we take ground of cross-examination in case of notice issued under section 74 with regard to fake invoices notice?
100%. And they will have to allow this.
Great. And I think one more question is missed. Okay, there is order passed. Dushant Kumar ji ka question hai. There is order passed in audit done by the department, and he has disallowed the legitimate credit which is apparent from the record. Can we file rectification of mistake with the adjudicating authority together with the appeal to first appellate authority? Please suggest which one option is suitable for us. Can we go for rectification against the order of audit?
For this, we'll have to. Yesterday only, I and Vishal Bhai was discussing the difference between rectification and revision. So for this, we need to look into this section very clearly. What can be rectified? Section 161. So it is not restricting anyone to an adjudication or to an audit. So if there is an order or a communication which has apparent mistake, then it can be rectified. So if it is apparent, then certainly it can be rectified. Or otherwise, if it is not being rectified, you can make an application for rectification. If he is not rectifying it, then you can very well approach the appellate forum. Or even the writ forum also can be approached. But if an order has been passed, because this is the question is qua the audit order. So audit order does not mean any time barring, and the appeal is not there, because audit order is merely the information that these are the liabilities as per them. Then they will have to raise a show cause notice for that, if I'm not wrong. So first you need to point out whether it is an show cause notice or the audit order. If it is an audit order, you can very well apply under 161 for the rectification. If it is a show cause notice, then at that stage, you cannot go for rectification. You will have to reply to that show cause notice.
There is one more question from Bhavniji. He already posted the question and he's reposting it. So the question is, but section 160 subsection 1 carves out an exception also if the action accepted is in conformity with or according to the intents, purpose and requirement of this act. This I feel is a safeguard to the taxpayer even if he participates in the proceedings. Kindly guide.
There is nothing to guide, sir. Only thing is the way we read the law.
Yes.
I am a person who read the law in my own way, and you read the law in your own way, and that is the beauty of law. मेरे को देखता हो तो मेरे को सही लगता है, आपको दिखता है गलत लगता है, या मुझे गलत लगता है आपको सही लगता है. That is the beauty of law, and that is how it has to be dealt with. So my answer would be, you can certainly take it as a safeguard to the taxpayer, but as per me, it is a safeguard to the officer, because something which is done wrongly is getting approved and the entire proceedings are not getting invalidated. So from that angle I'm saying कि अगर आप गलती भी करोगे और गलती करने के बाद if it is being upheld those proceedings, then in that case it is always goes in benefit of the tax authority as per me.
So I'm taking the last question, and before that, I would like to tell everyone that on the Zoom, we also have the react option in the bottom. So if you like this webinar, you can react with the thumbs up or whatever you want to react. There is a react option in the bottom line. So
Yeah, everybody should also join our that YouTube channel also. That is
yes.
also there.
Okay, so last question was, one second.
Also, again, I would like to inform that specifically keeping all these queries in mind and on repeated request to Dr. Avinash Bhaiya, we are curating a special 4-day course, which will be fully addressed by Avinash Bhaiya. We'll be sharing
4 day,
very
3
soon
hours.
the details.
4 day, 3 hours per day.
4 day, 3 hours each. And it will be fully addressed. And it would be, as he was mentioning, that we have a mindset of compliance. Like majority of us started as a CA practitioner, and over a period one by one we all shifted to litigation. Now many of you are in that pursuit that you also want to switch to litigation. Many times in all our sessions people come and ask you how we can take it up. So keeping this in mind, Avinash Bhaiya would be taking those 4 sessions exhaustively, 3 hours each, and we'll be very soon announcing that. And I'll request that you all should definitely join that particular course, because it would be a great value add, specifically keeping that now even the income tax law has been redrafted. So again, it will come up with lot many litigations. And now very soon we have the GST tribunal coming up. So for both direct and indirect tax aspect, that course would be a great value add. Over to you, Shefali ma'am.
So this is the last question I'm taking. It is again the question from Bhavneet Kaurji. He's saying if SCN is issued by the anti-evasion already, then can DGGI investigate the same matter again?
Armor Securities, please read that.
Good.
It has dealt with this issue in very great detail. And even after reading that, if the query is not resolved, kindly be in touch with me. I'll reply to your query.
Great.
Anyways,
So,
our next session is on armor only.
Yes. Securities you can read. And if you
Yes.
don't find time for that, you can join our next session on the next Friday. We will be keeping it on the same judgment, that is of armor security.
Exactly.
Okay.
Fine. So ma'am, I think you can give the closing remarks.
So I think it was a beautiful discussion, and the inputs from Avinash ji, Vishal ji, Pramod ji, and all of the participants were excellent. And I'm very happy to see a lot of participation from all of the different tax consultants, advocates, as well as chartered accountants. And I would like to invite all of you for our next session that will be on the next Friday. And I hope you will find that too very interesting. And also very soon, I will be releasing the first brochure for the GST 80 course. which will be covering the practical aspects, not just the theoretical, but the practical aspects for the GST practice and even the other legal practices if you want to enroll into it. So with this, I
That
would
is
like
a four-day litigation
it's a
course.
four-day package. So all of the other details I will release.
Yeah.
Shall
So
now we can close it.
yeah. Thank you all. Thank you
Thank
for
you. Thank
joining.
you very much.
And we look forward to meeting you all on the next Friday, same time, with the another very important judgment setting various legal precedents, that is the Armour judgment. Maybe you all can in the meantime go through the judgment so that you all can be ready with your queries particular to that particular judgment and the various legal doctrines. So thank you all. Thank you very much. Thank you, Avinash Bhaiya.